Chapter 1, the Uniform Commercial Code. 1. Uniform Commercial Code Overview. The focus of this course is UCC Article 2. However, before we focus on Article 2, you must be introduced to the entire UCC. Most law students taking this course will be somewhat familiar with the UCC because they studied portions of Article 2 in their contracts classes. Therefore, this chapter presents only a quick overview of the UCC. It next emphasizes important parts of Article 1, which you will need to learn and use whenever you solve a sales problem, and then introduces Article 2. Figure 1-1 on the next page gives you a quick glimpse at the basic coverage of the UCC. What else do you need to know? Does the title accurately describe the statute? Critics suggest that the UCC is not really uniform. No state has adopted the UCC verbatim, and there are conflicting judicial interpretations of certain code provisions. Hence, it is not truly uniform. The UCC does not apply solely to commercial transactions. A common student misconception is that the UCC applies only to transactions involving merchants, but except for specific provisions of the UCC, it applies equally to transactions when one or both of the parties are not merchants. Hence, it is not truly commercial. Indeed, it is not really a code in the civil law sense of the meaning of the term. However, it is one of the most successful of the uniform laws to be promulgated by its sponsors, the Uniform Law Commission and the American Law Institute. The UCC has been enacted into law with some variation in every state in the United States. Figure 1 shows Article 1 gives general provisions, Article 2, sales, Article 2A, leases, Article 3, negotiable instruments, Article 4, bank deposits and collections, Article 4A, funds transfers, Article 5, letters of credit, Article 6, bulk sales and repealer, Article 7, documents of title, Article 8, investment securities, Article 9, secured transactions. As Figure 1 illustrates, the UCC addresses almost every aspect of a typical commercial transaction. UCC Article 1 is applicable to all other UCC articles. It contains basic definitions and some of the most important concepts students need to learn and use whenever they solve a UCC problem. Article 2, sales, contains the rules applicable to contract formation, performance, breach, and remedies when a transaction involves the sale of goods. Article 2A provides similar rules to govern leases of goods. 3, 4, 5, and 4A and 5 concern methods of payment. Article 6 governs bulk sales. 7 deals with the shipment and storage of goods. 8 governs certain transactions involving investment securities, and Article 9 addresses personal property secured financing. Articles 10 and 11 contain transition provisions which determine what version of the UC applies to a transaction. Based on the date of the transaction and the effective dates of different versions of the code, a typical commercial transaction may involve legal concepts drawn from all or most of the articles of the UCC or from just 2 or 3 of them. For example, the sale of goods implicates Article 1 and Article 2, since goods must be paid for. Any of the Articles 3, 4, 5, or 9 may be involved as well, depending on the type of payment called for in the transaction. On the other hand, a straightforward secured loan transaction might involve only Articles 1 and 9. Because the UCC is a statute, students should always begin their analysis of a legal problem by reviewing the applicable parts of the statute. Therefore, they should always have a copy of the UCC with its official comments on hand. Students will find it helpful to put index tabs in their copy of the UCC so that they can quickly move from article to article and so that they quickly can find important definitions. Before you read the rest of the chapter, look at your copy of the UCC. Start with the table of contents, which lists every article by title. Note how code sections are constructed. Each article in the UCC is divided into parts, which are further divided into sections. The sections are sometimes divided into subsections. The UCC sections consist of 4-digit numbers representing the article, part, and section number. Thus, in Figure 1-2, the code shows you the construction of UCC code section and gives advice for tabbing the code. Part 2 of this chapter is titled Article 1. Next, look at the table of contents to Article 1 that appears at the beginning of that article. It provides a convenient outline of Article 1's contents. Note The scope of Article 1, Section 1-102 states, this article applies to a transaction to the extent that it is governed by another article of the UCC. Section 1-102, therefore, tells you that when you analyze a problem within the scope of Article 2, you need to incorporate the applicable general provisions of Article 1 into your analysis. As you work on Article 2 problems, you will often need to refer to certain sections in Article 1, especially 1-03, Rules of Construction, UCC Purposes and Policies. 1-202, Notice Knowledge. 1-205, Reasonable Time, Seasonableness. 1-302, Variation of Agreement. 1-303, Course of Performance, Course of Dealing, and Usage of Trade. 1-304, Good Faith. 1-305, Remedies to be liberally administered. The concepts of course of performance, course of dealing, and usage of trade are so important through the sales course that we introduce them now. The basic notion is that when parties have been performing a specific contract in a particular way, course of performance, it makes sense that the performance reflects their understanding of the contract. Accordingly, if a dispute arises over a specific term and the parties have previously acted in a way that sheds light on the meaning of that term, their course of performance is important to explain what the parties intended that specific term to mean. For example, if an installment contract provides for payment within 5 days of an event and the parties have always made and accepted payment within 5 days of that event, business days of that event, their course of performance shows that they must have meant that 5 business days rather than 5 calendar days would be used to calculate the time for payment. Similarly, if the parties had several contracts in the past or the same goods as are the subject of a new contract, and each of the past contracts contained a particular term, if the parties leave that term out of the new contract, it is likely that they both intended the same term to prevail, but took it for granted because of their past history. Thus, their past course of dealing is probative to understand their current contract. Finally, where the contract parties both have experience in a particular trade and in that trade a term has a particular meaning, or most contracts contain that particular term, it is very possible that they would assume that term would be part of their contract, even if they did not express it. Therefore, the usage of trade can shed light on the party's intention with respect to the current contract. Figure 1-3 suggests an easy way to remember what each of these terms represents. And asks as exercise 1-2 to read course of performance, course of dealing, and usage of trade. Part 3, the official comments. Each code section is followed by an official comment. The drafters wrote the official comments to clarify or expand on the statutory text. On occasion, you will see an official comment that seems to contradict the statute. Be careful. Remember that although the comments are sometimes easier to read than the statutory text, they are not part of the statutory text. When state legislatures enact the code, they do not enact the official comments as law. Accordingly, the official comments are neither law nor do they have the force of legislative history. Technically, if a comment conflicts with the text of the code controls. Nevertheless, even if the comments are neither statutes nor legislative history, they are very persuasive authority, and the vast majority of courts, commenters, and lawyers consider the comments of virtually equal status with the code, citing the comments liberally to construe the code's meaning. Part 4, UCC amendments. The UCC has been amended several times since its promulgation. In 2003, after many years of debate and negotiation, the sponsors published a revised Article 2. However, no states ever adopted revised Article 2, and on May 11, 2011, the American Law Institute withdrew the 2003 proposed amendments to Articles 2 and 2A from the official text of the UCC. For that reason, this book continues to study the old pre-2003 version of Article 2. However, Article 1 was revised in 2001, and the revised version has now been adopted in more than half the states of the United States. Therefore, although all references to Article 2 are to the old Article 2, all reference to Article 1 are to the new post-2001 Article 1. When you read cases, you should keep in mind that the cases may be citing to different versions of Article 1. For convenience, Appendix 1 in this book contains a table reflecting key differences between the old and the new Article 1. Part 5, relationship of UCC to other laws. As you study the UCC, you will encounter many familiar concepts. You have studied some of these concepts in your contracts, torts, or property classes. The UCC supersedes some of these areas of common law. However, in other instances, common law supplements the UPC. You will find, therefore, that this course is a helpful review of many common law concepts. Section 1-103 makes the key statement of this relationship between the UCC and common law. It provides that 1, the UCC may displace other bodies of law. In other words, if there is a conflict between the UCC and common law, the UCC prevails. And 2, unless displaced by particular provisions of the UCC, the principles of law and equity supplement the code. You will need to refer back to Section 1-103 constantly when Article 2 does not spell out a legal rule necessary for your analysis so that you can supplement Article 2 with common law rules. Part 6, Article 2, Overview. Before we study the trees, the individual sections of official comments in Article 2, take a quick look at the entire forest. An overview of the contents of Article 2. It is easier to understand the individual code sections by looking first at the entire forest. Also, this section introduces some key concepts that you will continue to encounter as you work with Article 2. Article 2 is organized chronologically, corresponding to the events in the life of a contract, as shown in Figure 1-4. In this text, we study in depth several issues that you first encountered in contracts, such as contract formation and remedies. We also study other issues that you encountered in torts, implied warranties. Finally, you encounter new concepts such as shipping terms and risk of loss. Some legal scholars suggest that the easiest way to understand Article 2 is to recognize that its organizational framework follows the life cycle of a sales transaction through 5 stages shown in Figure 1-4. If a contract is performed as the parties intended at the time of contracting, after the contract is performed successfully, the parties are likely to enter into subsequent agreements and the cycle repeats itself. So in Figure 1-4, life cycle of a sales transaction shows agreement, post-agreement, pre-shipment, shipment and delivery of the goods to the buyer, receipt and inspection by the buyer, payment by the buyer. Students with a business background often find this analytical approach to be very meaningful. However, most students are more comfortable with an approach that poses a series of questions relating to the chronology of contract formation and performance, which is the order that this book follows. Figure 1-5 is a list of the questions we will address with an indication of where the book discusses those questions. You can use this series of questions as your basic outline for analyzing a code problem. Is a transaction in the scope of Article 2? You look at that in Chapter 3 of this book. Is there a contract? See Chapter 4. Are there any defenses to formation contained in Chapter 5? What are the terms of the contract? Chapter 6, 7, and 8. What are the respective performance obligations of the parties? Chapter 9. What are the respective... Is there any legal excuse for non-performance? Chapter 10. Has either party failed to perform breach? Chapter 11. And Chapter 12 contains appropriate remedies for a breach. So there's an exercise and additional resources before entering into Chapter 2.